Understanding the differences between a last will and testament versus a self-directed revocable trust. In this video, we'll explore the key distinctions between a last will and testament and a self-directed revocable trust where the trustor and the trustee are the same individuals retaining full powers. What is a last will and testament? A legal document outlining how a person's assets and properties are distributed after death. It only takes effect upon the individual's death, and it must go through the probate process, which can be time-consuming and costly. A living will provides less privacy since it becomes a public record once it's filed in probate court. A will is a love letter to the judge, and if you are talking to a judge, you are in the wrong place. If you do not own property, a last will and testament is just fine. But if you do own land and property, then you need a trust. Why should you consider a revocable trust over a will? A trust avoids probate, which means assets can be distributed to beneficiaries without court involvement, saving time and money. Offers more privacy since it doesn't become a matter of public record like a will filed in probate court. Allows for a smoother transition of assets in case of incapacity since the successor trustee can take over management without the need for court intervention. What are the key differences? Timing. A will takes effect after death, while a trust can be effective during the trustor's lifetime and after death. Privacy. Trusts offer more privacy than wills as they do not become public records. Flexibility. Trusts provide more flexibility and control over asset management, especially when the trustor and trustee are the same person. In summary, while both a last will and testament and a self-directed revocable trust serve to distribute assets, they differ significantly in terms of timing, probate involvement, privacy, and flexibility. What are the typical problems of an estate using a will? If a will was signed and dated a long time ago, but there have been new deaths and births in the family since then, here are some important considerations. The probate system is not a fan of outdated wills, and the judge will have to make estate planning decisions. The legal term when the judge has to solve your family problems for you when you have an outdated will is called intestate. What would happen if you forgot to mention a few deaths and births in your family if you owned a trust? The trust will automatically determine whether the assets of the predeceased person are divided among the remaining beneficiaries or passed down to his or her children. What makes a trust so different from a will is a trust changes the title of an asset in life. That is how you avoid probate. A will is a prescription for probate, so that means the title of the property will be changed after death. When you make a trust, you do something called fund a trust. That means you have a new deed that transfers the property from your name into the family trust. That deed will come with your trust kit, and it will then have to be signed, dated, and notarized. Then recorded at your local courthouse, thus avoiding probate. A last will and testament will never change title of your assets. To avoid unintended consequences, it's crucial to update the will and your trust when you have a birth of a new grandson, for example. The nonprofit trust company will help you navigate through the estate planning process. We will help you transfer your legacy seamlessly to your heirs, bypassing probate, and support a nonprofit through a tried and true nationally recognized trust. Find budget-friendly estate planning solutions that encourage a legacy gift to your favorite nonprofit organization. Thank you for watching. Be sure to visit www.nonprofittrust.net.